Being asked to serve as the trustee of the trust of a family member is a great honor. It means that the family member trusts your judgment and is willing to put the welfare of the beneficiary or beneficiaries in your hands. But being a trustee is also a great responsibility. You need to go into it with your eyes wide open. Hi, I'm Antoinette Bone, estate planning, probate, and elder law and guardianship attorney in the Dallas-Fort Worth Metroplex. And today I'm going to tell you 6 questions you need to ask before saying yes to serving as a trustee. Just remember, this video is for educational purposes only and does not create an attorney-client relationship. Please seek professional legal advice for your situation. Number 1, ask to read the trust. The trust document is your instruction manual. It tells you what you should do with the funds or other property you will be entrusted to manage. Make sure you read it and understand it. Ask the drafting attorney any questions you may have. Second, find out what the goals of the grantor, that's the person who created the trust, are for the trust assets. Unfortunately, most trusts say little or nothing about their purpose. They give the trustee considerable discretion about how to spend trust funds with precious little or no guidance on what to consider when making a distribution. Often the trust says that the trustee may distribute principal for the benefit of the surviving spouse or children for their health, education, maintenance, and support. Now, is this a limitation, meaning you can't pay for a yacht despite arguments from your son that he needs it for his mental health? Or is it a mandate that you pay to support the surviving spouse even if he or she could work and it means depleting the funds before they pass to the next generation? How are you to balance the needs of current and future beneficiaries? It is important that you ask the grantor while you can. It may even be useful if the trust creator can put his or her intentions in writing in the form of a letter or memorandum addressed to you if the trust provides no guidance. Third, find out how much help you will receive. As a trustee, will you be working on your own or working with a co-trustee? If working with one or more co-trustees, how will you divvy up the duties? If the co-trustee is a professional or an institution such as a bank or trust company, will it take charge of investments, accounting, and tax issues and simply consult with you on questions about distributions? If you do not have a professional co-trustee, you can hire attorneys, accountants, and investment advisors as needed to make sure you operate the trust properly. That's something you should know. Number 4. Next, ask, how long will your responsibilities last? Are you being asked to take this duty on until the youngest minor child reaches age 25 or some other stated age? In other words, for a clearly limited amount of time or for an indefinite period that could last the rest of your life? In either case, under what terms can you resign? Do you name your successor or does someone else? 5th, ask, what is my liability? Generally, trustees are relieved of the liability in the trust document unless they are grossly negligent or intentionally violate their responsibilities. In addition, professional trustees are generally held to a higher standard than family members or friends. What this means is that you won't be held liable if, for instance, you get professional help with the trust investments and the investments happen to drop in value. However, if you use your neighbor who is a financial planner as your advisor without checking to see if he has run afoul of the applicable licensing agencies and he pockets the trust funds, you may be held liable. A well-respected Massachusetts attorney who served as trustee on many trusts used a friend as an investment advisor who put the trust funds in risky investments just before the 2008-2009 stock market crash. The attorney was held personally liable and suspended from the practice of law. So, Be careful and read what the trust says in terms of relieving you of personal liability. And finally, ask, how will you be compensated? Often family members and friends serve as trustees without compensation. However, if the duties are especially demanding, it is not inappropriate for trustees to be paid. The question then is, how much? Professionals generally charge an annual fee of 1% of the assets in the trust. So the annual fee for a trust holding $1 million would be $10,000. Often professionals charge a higher percentage of smaller trusts and a lower percentage of larger trusts. If you are doing all of the work for a trust, including investments, distributions, and accounting, it would not be inappropriate to charge a similar fee. However, if you are paying others to perform these functions or acting as co-trustee with a professional trustee, charging this may be seen as inappropriate. A typical fee in such a case is a quarter of what the professional trustee charges, or 0.25%, often referred to by professionals as 25 basis points. In any case, it's important for you to read what the trust says about trustee compensation and discuss the issue with the grantor. If after getting answers to all these questions you feel comfortable serving as trustee, then by all means, accept the role. It is an honor to be asked, and you will provide a great service to the grantor and beneficiaries. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, tell your family and friends. Thanks for watching, and I will see you next time.